Here is the thing about Rhode Island's Assault Weapons Ban Act, Senate Bill 359, that makes it different from every other state assault weapon ban you have been hearing about this year. Virginia's ban was signed in May 2026, giving gun owners weeks to respond. Rhode Island's ban was signed into law in June 2025. That is not a typo. Rhode Island's governor signed this legislation almost a full year before it takes effect, with an effective date of July 1st, 2026. Which means that while Virginia gun owners have been scrambling over recent weeks, Rhode Island gun owners have had an entire year during which this law has been sitting on the books, unnoticed by the majority of people it affects, ticking toward an effective date, now weeks away. If you are a Rhode Island gun owner who does not know about Senate Bill 359, you are exactly the person this video is for. By the end of this video, you will know all the implications. So let's get into it. Because the exemption clause, the provision that protects your right to keep firearms you lawfully own before the ban takes effect, closes on July 1st, 2026, and the time you have left to act under its protection is measured in weeks, not months. Subscribe right now because the exemption clause in S359 is the single most important legal protection available to Rhode Island gun owners right now, and the window to act closes permanently on July 1st, regardless of pending lawsuits or constitutional challenges. S359 restricts the manufacture, sale, and purchase of defined assault weapons in the state. It does not prohibit existing ownership. That is the function of the exemption clause, which protects firearms lawfully owned before the effective date. The law was signed in June 2025 and spent nearly a year as enacted law with a future effective date, meaning restrictions were not yet operative, but the clock was already running. Any Rhode Island resident who purchased a covered firearm between June 2025 and June 30th, 2026 acquired it during the exemption window and is protected. Any Rhode Island resident who waits until July 2nd is too late. Let me break down what S359 restricts, what the exemption covers and does not cover, why Rhode Island's legal environment makes this ban especially durable, the constitutional challenge landscape in the First Circuit, and what every Rhode Island gun owner needs to do before the effective date. Number 1. What Senate Bill 359 restricts. The 3 prohibited activities. S359 restricts 3 categories of activity involving defined assault weapons: manufacture, sale, and purchase. This is narrower than some comparable state bans, which also explicitly prohibit importation and transfer. Manufacture prevents Rhode Island-based production of covered weapons. Sale prevents Rhode Island dealers from selling covered weapons. Purchase prevents Rhode Island buyers from acquiring covered weapons through any sale transaction. The defined assault weapons category. The law's operative scope follows the feature-based approach used in similar state bans. Defined assault weapons typically include semi-automatic centerfire rifles with specified features, pistol grips, adjustable or folding stocks, flash suppressors, forward pistol grips, barrel shrouds, as well as semi-automatic pistols with analogous features and semi-automatic shotguns with certain configurations. The practical effect is that the most commonly sold configurations of AR-15 pattern rifles, AK-47 pattern rifles, and other modern sporting rifles fall within the definition, while fixed stock configurations and traditional sporting platforms in similar calibers remain outside it. What is not restricted? Firearms that do not meet the assault weapons definition remain available. Traditional hunting rifles in any caliber, bolt-action, lever-action, and pump-action rifles and shotguns in any configuration, and semi-automatic firearms with none of the defined features. The restriction is features-based, not name-based or caliber-based. Number 2. The exemption clause and what it actually protects. What the exemption covers. S359 contains an exemption for firearms lawfully owned prior to July 1st, 2026. If you own a covered firearm and owned it lawfully before that date, you are exempt from the law's restrictions as applied to that firearm. You can continue to possess it, use it at ranges, and use it for lawful purposes. You are not required to surrender, destroy, or register it with any state authority. What the exemption does not address. The exemption protects existing lawful ownership. It does not clearly address what happens when an exempted owner wants to sell, gift, or otherwise transfer a covered firearm after the effective date. The law prohibits sale of covered weapons. But does that prohibition apply to a private transfer of an exempted firearm between Rhode Island residents? This question is not clearly answered in the statutory text and will require either regulatory guidance from the Rhode Island Attorney General or judicial resolution once enforcement begins. If you have a covered firearm and anticipate wanting to sell or transfer it after July 1st, consult a Rhode Island firearms attorney before proceeding. The documentation challenge. The law was signed in June 2025. Many Rhode Island residents purchased covered firearms during the past year without awareness that those purchases were occurring within an exemption window. A purchase made in October 2025 is protected, but the buyer may have no particular receipt demonstrating the purchase happened before July 1st, 2026. Review purchase documentation for any firearms that might be covered. Gather purchase receipts, FFL transfer records, and bank or credit card statements. If you purchased through an FFL during the exemption period, that FFL's bound book records the transfer date. Number 3. Why Rhode Island is a particularly challenging legal environment for challenges. The First Circuit context. Rhode Island is in the First Circuit of the United States Court of Appeals, which also covers Connecticut, Massachusetts, Maine, and New Hampshire. The same court that decided Beckwith v. Frey, the April 3, 2026 decision upholding Maine's 72-hour waiting period as a modest and historically analogous delay, is the circuit that would hear challenges to S-359. That ruling tells you how the First Circuit applies Bruin. It is willing to find historical analogs supporting state gun regulations, treats the standard as requiring analogs rather than identical historical twins, and characterizes moderate burdens as constitutionally modest. That is not the most hospitable circuit for an assault weapon ban challenge. The Heller common use argument. The strongest constitutional argument against assault weapon bans is that Heller protects arms in common use for lawful purposes. AR-15 pattern rifles, more than 20 million in American civilian ownership, are by any measure in common use. A court applying this standard faithfully should find the argument compelling. The question in the First Circuit is whether the court will apply the common use standard to feature-configured semi-automatic rifles or will find a narrowing principle, treating military-configured features as dangerous and unusual despite common civilian ownership. The strategic positioning problem. Rhode Island's law was signed in June 2025. Any challenge to the law must address why it was not brought sooner during the nearly year-long period between enactment and the effective date. The state will argue the absence of a pre-effective date challenge suggests the law's constitutionality was not clearly challenged. Gun rights organizations will argue that challenges before an effective date are premature. This timing dynamic may factor into how courts assess the merits of the challenge. Number 4. The purchase decisions and action plan before July 1st. If you want to own a covered firearm, the manufacture and sale restrictions take effect July 1st. After that date, a Rhode Island dealer cannot sell you a covered firearm. An online retailer cannot ship a covered firearm to a Rhode Island FFL. If you want a standard configuration AR-15, an AK-47, or any other covered firearm as a Rhode Island resident, the legal window closes June 30th. The practical purchasing timeline. As July 1st approaches, Rhode Island residents wanting covered firearms will concentrate purchases at dealers and through online retailers. Inventory of covered firearms may become limited in the final weeks before the effective date. If you have decided you want a covered firearm under the exemption's protection, purchasing now rather than in the final days of June is the prudent approach. Magazine purchases. If S-359 includes magazine capacity restrictions, and comparable Rhode Island legislative efforts have included such provisions, magazines over the defined capacity limit face the same purchase before July 1st analysis. Confirm through the current text of S-359 whether magazine restrictions are included in the bill's operative provisions. Before July 1st, identify any firearms you own that may be covered. Gather purchase documentation confirming acquisition before July 1st, 2026. If you want to acquire a covered firearm, do so before the effective date and retain all documentation. Review S-359's specific text through the Rhode Island General Assembly website to confirm precise coverage. After July 1st, the exemption protects your existing covered firearms for possession. Be cautious about any post-July 1st transfer of a covered firearm until legal guidance clarifies whether the sale prohibition applies to transfers of exempted firearms. Monitor constitutional challenge litigation. Gun rights organizations are expected to file challenges in the District of Rhode Island, and any preliminary injunction would pause enforcement. But do not make purchasing decisions based on an anticipated favorable First Circuit ruling that may not materialize. Know the First Circuit's approach. The circuit that upheld Maine's waiting period will review any S359 challenge. Manage expectations. Do not substitute anticipated judicial relief for action before July 1st. Consult a Rhode Island attorney about specific questions regarding coverage, exemption documentation, and the legality of post-July 1 transactions involving exempted firearms. Bottom line: Rhode Island's Assault Weapons Ban Act, Senate Bill 359, was signed in June 2025. Takes effect July 1st, 2026. Restricts manufacture, sale, and purchase of defined assault weapons. Contains exemption protecting firearms lawfully owned before July 1st, 2026 from possession restrictions. The exemption window closes July 1st. Purchase covered firearms before that date if you want them with exemption protection. Document all purchases with dated receipts. Understand that the First Circuit, which just upheld Maine's waiting period, is unfavorable for constitutional challenges to this ban. Monitor litigation for any preliminary injunction, but do not rely on judicial relief as a substitute for action before the effective date. Subscribe because the constitutional challenges to Rhode Island's assault weapon ban will move through federal district court and the First Circuit in the coming months, and every development affects whether S359 remains in effect or is enjoined.